On the 14th of December 2023, the European Court of Human Rights decided the case of ML v. Poland. It was a much-awaited sentence, as it followed directly the judgment by the Polish Constitutional Tribunal regarding abortion in Poland, the judgment that, as many of you will recall, introduced a near-total ban of abortion in Poland. ML v. Poland has been much awaited, as it seemed that it's an excellent candidate for a landmark case in the European Courts of Human Rights conservative position on abortion laws. ML v. Poland was a much-awaited case because it seemed a perfect candidate for a landmark one. The applicant, a Polish national, a woman born in 1985, became pregnant in 2020. The fetus was diagnosed with a trisomy 21 or Down syndrome, and the person in question sought legal abortion, which was then available under Polish law. The abortion was granted and scheduled, and it was subsequently cancelled, because in the meanwhile, the judgment of the Polish Constitutional Tribunal prohibiting abortion for fetal malfunction or abnormality came into force. The person in question, the applicant, was denied abortion in Poland and went to seek legal abortion abroad in a private clinic. The applicant argued the violation of the right to privacy, among other things. And the court, by a vote of 5-2, decided that there was indeed a case of a violation of a right to privacy, to private and family life, to be more exact, in this case. Henceforth, the international press acclaimed the case as a breakthrough moment, as a landmark in the otherwise conservative policy of the court regarding abortion laws. But is it actually such a very important decision? It is, I would say, but for a different reason entirely. In fact, the court did not find the applicant's statements justified by the fact that there was indeed an infringement of her right to privacy. The reason why the case was won by the applicant against Poland was that the Constitutional Tribunal of Poland was not a body legally endowed with a power to introduce a binding restriction on the right to privacy and family life. To my mind, it is not a case about abortion law at all. It is a case about the rule of law. And it is a case about the intrinsic relationship of human rights, reproductive rights in particular, and the rule of law as a general setup in which the lawmaking in any Council of Europe country must take place. Poland fell short on the rule of law standards. Its constitutional tribunal was not a court that could make a valid decision on the constitutionality of any law, including abortion law. That's what the European Court of Human Rights says in ML v. Poland. It doesn't say that the infringement in itself or the restriction of the right to abortion was in violation of human rights. Therefore, we have two lessons to be learned from this case. First of all, it would be premature to acclaim ML v. Poland as a breakthrough. It is not a breakthrough. In fact, it is a continuation of the previous line of the court on abortion matters. Nonetheless, it is a very important judgment because what it means is in fact that anything that happened after the Constitutional Tribunal's judgments of 2020 in Poland, in healthcare, in abortion care, in post-abortion care, in prenatal diagnostics, that would be drawn causally to this judgment that entered into force in January 2021 was in violation of human rights as far as it led to a restriction to any of them. It is a very important conclusion. While ML v. Poland is an important judgment for women and other pregnant persons seeking redress of the violations of their human rights after the 2020 constitutional judgment in Poland, there are also some news that really support the thesis that the European Court of Human Rights did not change its mind regarding the abortion laws and abortion prohibition in Poland. In December 2023, the European Court of Human Rights declined 927 applications coming from Poland, all of them from women in childbearing age, all of them essentially arguing that the near total prohibition of abortion is in violation of their human rights. And in those cases, the court decided that there was no sufficient ground for it to look into the matter because it was hypothetical, because the new laws that were created in Poland, or allegedly created as it turned out since the judgment was itself an illegal intervention in the legal system, this regulatory state was not enough in itself to constitute an infringement on the rights of Polish women and other people who were or could be pregnant. It's not that the court has pronounced an opinion on Polish law. It has pronounced an opinion that continues its well-established line on the rule of law and on the status of Polish Constitutional Tribunal. ML v. Poland is an important judgment for the upcoming changes in the state of regulations and legal practice in Poland after the elections of the 15th of October 2023. Following the elections, the National Conservative majority that was directly politically responsible for the restriction of the right to abortion in Poland has given power over to a new coalition that is central, left, conservative, liberal, for lack of better mix of words. This coalition has promised to tackle the matter of abortion in Poland, but it has also promised a reinstatement of the rule of law in the country. So these two now, the rule of law and abortion, have also come to be intrinsically connected in Polish politics again. And we will be very much looking forward to further developments in that matter.